All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-7015, UAB Skyroad Leasing, appellant versus Ojsc Tajik Air, the Republic of Tajikistan. Mr. Krayan for the appellant, Mr. Suleiman for the appellate.
Good morning, counsel. You may proceed.
Good morning, Your Honors. It's an honor and a pleasure to be here in person with at least two of the judges, and good morning, Judge Rogers, and with counsel. The district court's piecemeal analysis of the circumstances of control and domination of Tajik Air by Tajikistan transformed the presumption of separateness into a conclusive presumption. The district court's own language reveals the piecemeal approach taken by the district court, which conflicts directly with this circuit's rule and requires reversal. The error here is the district court made it an irrebuttable presumption on a motion to dismiss.
In fairness, counsel, I understand that the district court opinion doesn't ever say that, and looking at everything together, but he does go through each of the arguments, and he does more than make a conclusory statement. He explains why he isn't persuaded by your argument. So where's the error?
Your Honor, I understand your point. The language of the district court that I'm pointing to is scattered throughout the opinion, and I'll show it to Your Honor specifically.
Okay.
For example, on the issue of—
Tell me where it is in the JA, and I'll bring it up.
Your Honor, we're starting with page A452.
Right.
On the issue of high-ranking government officials occupying all seats on the board, the district court stated, quote, "The presumption cannot be overcome simply because high-ranking officials sit on the board." On that same page, the district court stated that this fact, quote, "by itself," close quote, was insufficient to overcome the presumption.
So that's the point of my question. He went through each of your objections and found them unpersuasive and said why. He never said, and looking at them all together, I conclude that you have not met your burden. Is that the error?
You are right, Your Honor. The district court did not follow circuit precedent set in 2020 in the TIG versus Argentina case, in which this court stated, quote, "We join several other circuits in holding that district courts should look to the totality of the circumstances to make this determination." Another example on page 448 of the JA. Regarding the facts of 100% ownership and the government's authority to appoint and fire the Director General, the district judge stated that these two facts, quote, "do not by themselves establish the required control," end quote. Your Honors, we never argued that those two facts by themselves establish the required control, but this language from the opinions shows that the district court conducted the wrong analysis. It's like pieces of a puzzle. The district court picked up each piece and discarded it without putting them together and seeing the full picture. It never got the view because
So where did you bring this to the district court's attention?
Your Honor, we stated throughout all of our briefs and in the hearing that it's the totality of the facts, not any one fact, that is determinative here. And that's why this decision must be vacated and remanded. That you cannot have an opinion out there that goes fact by fact, discards each one, but never gives the petitioner the ability to present the total facts and circumstances. For example, on the fact that they were represented by a civil servant, non-lawyer, head of the transportation department, the district court stated at 457 that fact, quote, cannot bear the burden of overcoming the presumption of separateness, close quote.
But Mr. Pride, I mean, in making a fact-by-fact determination, I mean, to take all of the facts in the totality, you still have to consider each fact along the way. And at the end of its discussion of this, I mean, the district court talks about the fact that that taking everything together, this is closer to the spectrum of cases in which there was, separateness.
Yes, Your Honor. But the language that I pointed to throughout the opinion shows the district court did not follow the analysis that this court set down, which is to examine the totality of the circumstances.
But why isn't what Judge Rao just pointed to where the judge did that?
Your Honor, the judge absolutely did not do that. And the reason I say that is based on the text of the ruling, the language that I just quoted to Your Honor, wherein the judge did not conduct the totality of the circumstances analysis, quite the opposite.
No, I don't understand your point. The judge said, look, you raised 10 points. I don't find each alone enough. And then at the end, the point that Judge Rao makes says, why isn't the judge saying, and looking at everything together?
Yes, Your Honor. And Judge Rao is absolutely correct. The district judge does intone that at the very end of the opinion, but the whole opinion leading up to that refutes that was the analysis conducted. Your Honors.
I don't understand. When the judge was considering allegation 1, was he supposed to say, I don't find this persuasive? And in the totality, I don't find it persuasive? As distinct from saying none of these facts that you allege is persuasive, and looking at all of them together. Why isn't that sufficient? I don't see our cases as limiting the judge or the district court the way you suggest, so long as the judge does at some point address totality. And I'm not even sure, I know one of my colleagues and I have had this discussion in another context, but I don't even know that it's necessary to do other than as the judge did here. That's what I'm trying to understand. What is, as it were, the prejudice to your client by the judge saying this alone doesn't do it, that alone doesn't do it, that alone, and taking all these things together, not enough. That's what I don't understand about this argument.
Yes, Your Honor. It is because this is a motion to dismiss. There's never been an evidentiary hearing held in this case. With facts such as 100% ownership, control of the board of directors, but also the government controlled each and every decision, large and small. It inserted their version of the FAA, the Civil Aviation Agency, into that airline, and that agency made every day-to-day business decision.
That's not correct. It's contradicted.
Yep.
Your Honor, that was never contradicted. In fact, there's no declaration that even mentions the CAA. And Tajik Air's brief never mentioned it.
What we do have is the recitation of decisions that were made apart from the CAA.
You are correct, Your Honor. But they never, this is a motion to dismiss. No evidentiary hearing's been held. They never even mentioned the CAA, Your Honor. They also never mentioned the written admission before this court that was in the underlying proceedings. They said that the government of Tajikistan, quote, determines both the complexity and length of the decision adoption process, these decisions are taken by the state through its institutions, close quote. That is more than sufficient to overcome a presumption at the outset of a case before an evidentiary hearing has been held.
So, I mean, the cases, I mean, of course, this is an inherently fact-specific inquiry, but it seems, looking at the cases, one of the primary factors from the case law is whether the instrumentality was acting on behalf of the state. And that seems to be a factor that gets a lot of weight. So what evidence is there that Tajik Air was acting on behalf of Tajikistan?
Your Honor, in this case,
Which is different from being controlled by it.
Yes. What is really happening here? The president of the country set up a different airline called Solon Air, owned by the brother-in-law of the president of the country. And they took steps of control and domination to suppress this particular entity, Tajik Air. They used it as their own agent, and they showed control and domination, not in the way Your Honor's talking about, but day-to-day control. For example, Your Honor, they passed a statute. They used that quintessential government power of passing a statute. It transformed and delved into every business decision and business relationship of this airline, and it transformed vendor debts into potentially worthless tax credits. That is government interference into the day-to-day business functions of the airline. And it's those totality of the circumstances, Your Honor, and that's why I think that this decision, which shows by its own language that the court went fact by fact, requires vacatur and reversal, just as this court did in the foremost McKesson versus Iran and the TIG against Argentina cases. We're at the outset of the case, Your Honors, and we had more than sufficient facts to overcome the presumption.
Let me ask you about one other passage in the district court's opinion. And this is at 447 to 448. 447, we're told Skyroad argues that the following facts overcome the presumption of separate. And there are then 7 itemized things. Following which the court says, these facts, these 7, taken as a whole, fall short of overcoming the presumption that it's separate from the sovereign. Now, was there anything besides those 7 that was in play?
Yes, Your Honor, but let me just take up directly the language that Your Honor is pointing to, because the district court's language leading up to that point made clear that the court looked at each piece of the puzzle and discarded it. In other words, the district court never looked at the forest. It looked only at each individual tree.
What's the answer to the judge's question?
The answer is yes. There are numerous other facts. For example, they appointed the head of the Department of Transportation legal department, a non-lawyer. He was the person who represented them in the underlying arbitration.
Right.
They
so
also,
according to the judge, there were those 7 facts we just referred to, and then there are actions taken in the arbitration. Right? And as to these 7, he's saying looking at them in the totality. So all that leaves out is the actions in the arbitration, right?
yes. And that's why, Your Honor, at the posture of this case, motion to dismiss without an evidentiary hearing being held, this opinion has to be vacated so that all those facts can be presented in their totality to the district court, exactly as this court did in those other cases. Here you have a piecemeal analysis that does not comport with circuit precedent.
So is your point that Tajik Air couldn't hire the head of the transportation department to represent it in the arbitration?
No, Your Honor, but the record says that the Department of Transportation itself is who made that appointment. So,
well, Tajik said, we need somebody. Who do you say?
No, that's not in the record, Your Honor.
No,
only
but you don't have the opposite in the record. That's what I'm trying to get at.
No, we do, Your Honor. It says the Department of Transportation appointed him. I know that it's strange.
At
but that's the kind
at whose request?
Your Honor, it did not say that there had been a prior request. That's the level of control here. The government controls this airline. Imagine
It seems
if
to me that you would have to show something more than make that leap that the department just inserted itself against Tajik's wishes.
Well, that was the plain language of the record, Your Honor. But imagine that.
I didn't find that, counsel, and I didn't see it in the judge's opinion.
You're right. The judge omitted that.
But where was it before him?
It was in the record where it said it was the Department of Transportation that appointed this individual, this civil servant.
I know, but it still doesn't say who requested it. Okay.
I see that my time has expired. May I briefly conclude?
Briefly.
Your Honors, nothing drives this point home better than the analogy brought up by the appellee in their brief to US-based airlines. We all know that the US government does not control a US-based airline, but a US-based airline would never have occasion to say that the US government determines both the complexity and the length of the decision adoption process. These decisions are taken by the state through its institutions. So we ask that you vacate this ruling.
All right, thank you. Whoops, sorry.
Thank you, Your Honor.
One of my colleagues have a question?
No.
Thank you. All right, counsel for appellee?
Thank you, Your Honor. May it please the court, Arsalan Solomon for Respondent, Appellee, Open Joint Stock Company, Tajik Air. The district court properly dismissed Skyroad's petition for lack of personal jurisdiction pursuant to the Due Process Clause of the Fifth Amendment because Tajik Air, a corporation wholly owned by Tajikistan, lacks minimum contacts with the United States. The district court arrived at this ruling by making findings of fact after examining the whole record in depth and hearing the parties in an oral hearing lasting over 90 minutes. Judge Mehta's opinion is detailed, comprehensive, and fits squarely within this circuit's precedent on the issue, in particular following Judge Ginsburg's opinion in Transamerica Leasing versus Venezuela. Your Honors, I'll jump straight to Judge Rogers' question, which was whether the lower court ever said whether the judge was looking at all the factors together. As pointed out by Judge Ginsburg, in fact, the record does show that the judge was looking at all the factors together. Judge Ginsburg pointed to A448 in the opinion, where the judge says these facts taken as a whole fall short of overcoming the presumption. But there's another part of the judge's opinion at the very end, at page A457 of the record, where the judge says, accordingly, the court holds that the facts offered by Skyroad to show Tajikistan's control over Tajik Air, when viewed as a whole, are insufficient to satisfy the principal agent exception to Banchek's presumption of separateness. And he goes on to say that this conclusion is reinforced by other cases in the circuit where that presumption is overcome, and he compares those cases to the case before him and showed that the factors in those cases were never present in this case. And one of those factors was the factor that Judge Rao mentioned, which was the factor of an indication that Tajik Air was acting on behalf of Tajikistan in some way to pursue some sort of government policy. Examples are, for example, Shohem v. Iran, where the finding of the court was that the bank in that case, which was nationalized, was carrying out the policy of the government of Iran to promote and sponsor terrorism. There is obviously no such promotion of any government policy here in terms of an airline carrying out its commercial activities and operations as an airline. There's another case, TMR Energy versus Ukraine, where the finding was that that particular entity, its expenses were being paid directly by the state, and it was implementing state policy. And of course, that finding is not present in this case, and that showing was not made by Skyroad in this case. Far from being.
Given those statements by the judge, what would appellate have to show? I mean, he says this is fraud and injustice, but would he have to show that the district court's findings were inherently incredible? I mean, normally that's a phrase referred to testimony, but just plain error here?
Yes, Your Honor, it would be clear error. They would have to show that there was a clearly erroneous finding by the district court in terms of the district court's consideration of all the facts here in this case. So,
for example, about the Department of Transportation appointing the representative, would he have to have some evidence to offer at that point? I mean,
well, Your Honor,
hypothetically, some written evidence of a request or no request or a request, but it was rejected by the Transportation Department. I mean, what is the level of overcoming
yes, Your Honor,
clear error, plain error standard in this case?
Right. The appellant would have to show that any particular fact, in this case, if they're arguing the appointment of this attorney, they would have to show that that particular fact somehow in the totality of the circumstances shows that the government of Tajikistan was exerting dominant and overall control over Tajik Air, or that it created some sort of principal-agent relationship. Now, on this fact specifically, counsel actually has it wrong on the record. First of all, the record shows that Tajik Air hired this gentleman, Mr. Hafizov, in his personal capacity for the arbitration hearing. And that's substantiated not only by Tajik Air's CEO's declaration to that effect, which is found in the record at A412, but in the arbitration proceedings themselves. At A51 of the record, the tribunal references an authorization letter from Tajik Air dated October 2017, authorizing Mr. Hafizov to represent Tajik Air. It is Skyroad itself that then asked the tribunal, the arbitration tribunal, to request from Tajik Air and Mr. Hafizov some sort of letter or authorization from the Ministry of Transport to show that he is allowed to represent Tajik Air in this capacity. And it is only after that request was made to the tribunal that Mr. Hafizov then went back to his Ministry of Employment and asked for such a letter of authorization. And this is at record A52. And then at record A54, we see that Mr. Hafizov does present a letter of authorization. It's not a letter of hiring. It's not a letter of appointment. It's not a letter of engagement. It's a letter of authorization in which the ministry where he is employed said he is authorized, he is okay to conduct this representation where he's representing Tajik Air in his personal capacity, which was explained in the declaration of the CEO of Tajik Air. So, Your Honor, I submit that the record is very clear and obvious that this particular hiring of this attorney, which happened during the arbitration proceedings, does not indicate the type of day-to-day control that Skyroad would have to show in order to overcome the presumption of ban check and trans-American.
Is it common in Tajikistan for government officials to also have private employment in terms of representing private parties? I mean, that's just something that would be fairly foreign to us here.
Your Honor, I'm not sure. I wish I knew more about the practice in Tajikistan. I will say, however, that Tajik Air used to be a state unitary enterprise, meaning it used to be completely owned by the government. And then it was reorganized and privatized in December of 2009. And that restructuring of it into a private corporation may have created some circumstances where the leadership at the time felt more comfortable in hiring an individual in an individual capacity who may have had experience in this particular industry to make this representation of Tajik Air at these arbitration proceedings. But again, the record is very clear that, and this is from the declaration of the CEO, that representation was always in his personal capacity, that he was paid funds in order for that representation. He was provided a per diem, his hotel costs were paid, and in fact, he was given money to pay for the fees in the court. There was a problem with that, but we don't have to get into that at this time.
Can you just speak a little bit about the equitable factors, right? So Tajik Air in the arbitration and in the Lithuanian courts argued that it was a state enterprise. Is that inconsistent with the position it's taking before this court?
Well, Your Honor, it's not correct that they argued that they were a state enterprise. That's actually not the case. In the arbitration proceedings in Lithuania, there was a provision of Lithuanian law, Article 12.3 of the Lithuanian Commercial Arbitration Act, which provided that state-owned entities need to get the permission of their parent in order to sign arbitration agreements. The argument made by Tajik Air at that time was simply that at the time the lease was signed, which was September of 2009, when Tajik Air was still a state unitary enterprise, that at that time it was clearly state-owned enterprise. It still is a state-owned open joint stock company, meaning that the state is the primary shareholder. But the language of the Lithuanian statute simply was looking at ownership, not control. It said that state-owned entities would need to get the permission of their parent. So the argument of Tajik Air was, well, there needs to be a showing that Tajikistan then had to give that permission. The tribunal and then the Lithuanian Court of Appeals held that, in fact, the Lithuanian law doesn't say that. It only applies to Lithuanian entities. So it's not applicable to any Tajik entities, and there's no provision of Tajikistan law that would require such permission. And so that argument failed. But there was no contradiction between that argument and the argument being made here in these proceedings. The argument before the district court is that as a private company, as a corporation that's separate from the state, that presumption of separateness can only be overcome by a showing of a particular amount of control over the corporation. And Skyroad, which has the burden to show that, did not meet that burden. Judge Mate looked at that very carefully. He said that there was no contradiction between these two arguments, and we submit that is correct. Also, in terms of the court's precedent on what standard is for looking at that equitable exception, the examples are always where the party is using a particular argument as both a sword and a shield, meaning that they are not only trying to use their status being state-owned in order to deflect jurisdiction, but they're also trying to invoke the U.S. courts for some sort of benefit. And that was most clearly demonstrated in the Banchek opinion, the Supreme Court's case in Banchek, where the Cuban state-owned entity had brought an action to seek payment on a letter of credit, and then it was seeking to use its state-owned status in order to prevent the hearing of a counterclaim, an offset claim. And the court held that that type of sword and shield usage was inappropriate. That's my time, Your Honor. Thank you so much. We respectfully submit that the district court's opinion could be affirmed on the opinion below. Thank you.
Thank you, counsel. Counsel for appellant?
Thank you, Your Honor. And to give Your Honor the specific record reference about the appointment by the Department of Transportation of the civil servant, non-lawyer, to represent them, it's in the paragraph numbered 45. It's in the record at page A54. But the language that cannot stand here, when the district court said, quote, by itself, close quote, at 452, by themselves at 448, simply because at 452, quote, bear the burden of overcoming at 457. Your Honors, this is the precise kind of case, such as the foremost McKesson case and the TIG case, in which this court vacates and remands for further fact-finding because no evidentiary hearing has ever been held. We're at the stage of a motion to dismiss. And Your Honor, to Judge Ginsburg's question earlier, They never mentioned the CAA in any declaration, the agency that controls their day-to-day operations. They never mentioned it in their brief. They never mentioned it today. They just seek to ignore the control by that federal agency. And I ask that your honors reverse on that basis. Thank you, Your Honor.
Thank you. We'll take the case under advisement. Deputy Clerk, will you call the next case?
Case number 21-1132. Michael Johnston, appellant versus Securities and Exchange Commission. Mr. Cohn for the appellant, Mr. Yoder for the appellate, Mr. Third for the intervener.
Counsel, you may proceed.
Good morning, Your Honors. Stephen Cohn for the petitioner, Michael Johnston. The SEC committed two errors. First, when it found that Johnston and Mittman were joint whistleblowers. Thereafter, when it ordered a payment of $13.5 million to a whistleblower who provided no original information.
If I understand the commission's argument, which focuses almost entirely on that word provided, that it hinges on the two men you just mentioned appearing jointly to provide the information, accompanied by a lawyer representing both of them. Is that correct?
Yes.
So why is it reasonable to say the two provided the information jointly? They both showed up, they provided the information.
The reason is because the record shows that only Johnston provided original information. And the key here...
Well, wait a minute. If all the information was provided by the two of them at the same presentation, how can one say that they didn't both provide it?
Because only Johnston presented the backtesting information.
You mean only he spoke at the meeting?
Only he spoke, and that's confirmed in an August 3 letter, JA 287. But more important, the definition of original information, which is the heart of this law, isn't predicated on presentation. It's part of it.
Well, that's how the commission sees it, right?
Exactly, that's their error. If you read the definition, only information that is derived from the independent knowledge or analysis of the whistleblower. You have to be the person with the real insider information.
Now you're taking issue with their definition or the statutory definition of the whistleblower, which can be two or more persons.
So what occurs is, and I'll get to that, but in the application for the award filed by the lawyer for Mittman and Johnston, he stated as follows: Michael Johnston analyzed internal documents related to the backtest and discovered that Citi omitted the material information, including the risk to investors that was 48%, not 7%. Consequently, the only person who meets the definition of providing original information in the application was Johnston. The commission completely ignored that side of the argument.
Johnston may have created the information, discovered it, what have you. He then takes someone along with him to provide it.
No, only Johnston presented it.
The word is provided, not presented, right? Where is it on 287? You referred me to 287 to say that only Johnston spoke at the meeting.
287, it states as follows. This is the letter that was sent directly after the meeting. It's also confirmed in 3 different affidavits.
So they're numbered paragraphs. Which one is it?
It's the very first sentence. In response to your request following Michael Johnston's presentation concerning those funds. And then furthermore, in numbered paragraphs 3 and 4, the lawyer says Johnston will review and present later. But all of the affidavits that were filed after the commission made its error in the preliminary determination all said Johnston. But what's critical here, this is such an important fact, is that presentation gets you nothing. It gets you nothing. If you look at the statute, the definition of original information, the statute says is derived from independent knowledge and analysis. Not known to the commission, this is the presentation side, from any other source unless the whistleblower is the original source of the information. In the application to the FCC,
Whistleblower can mean 2 or more persons.
the term whistleblower has 2 different meanings in the statute. First off, Mittman was a whistleblower.
Is that a point on which the commission disagrees with you? Or?
They don't deal with that. They lump them together to their advantage. The definition of whistleblower covers those who seek protection under the anti-retaliation provision. You don't need to give original information. You only have to present information to the commission. That's Digital was very clear about that, the Supreme Court. But Congress was so focused on who do you give the money to, not who do you protect, like in a normal whistleblower statute, but who do you hand over potentially large sums of money? So they laser focused on this concept of original information. And they said only that person. Now, how do we know that this lumping together doesn't work? Because if you look at the application process for an award, they don't say a whistleblower applies for an award. They say you in applying for an award. And the statute, the regulation, the form says original information that you provide. So in the application process, the commission can weed out those who are mere whistleblowers. There's 60,000 of them. People who present, who give information, who may be helpful. That's great. Don't let them be fired. But if you're going to hand over potentially millions to a person, Congress wanted to get what it was paying for. They wanted to get, and if you look at the requirements, they wanted to get the real whistleblower, the person with the actual knowledge, the real insider. And then they had a series of other steps. One of those steps is you obviously have to give it to the commission, and they have to have a successful enforcement action of over 1 million. So they don't want trivial information. They want real, solid information that can sanction a company for 1 million. And then there has to be a finding by the commission that your information contributed materially to that sanction. And the SEC investigator confirmed all of that. The SEC investigator said the back test was it, that the back test contributed. And then this whole thing on presentation, if you go through the affidavits, what you will see is only Johnston presented on back test. He discovered it, he presented it. So if you carefully just weave through it, you'll see every meeting that is identified as having original information, the back test. Just if you comb through the affidavit, I know it's a job, but you'll see it's only Johnston presenting. It was his discovery.
Does everyone get a meeting?
Pardon?
Does everyone who ultimately gets a reward? previously have had a personal meeting with the commission?
No.
So
You only have to give the information. You do it by letter, TCR. And because you can be anonymous, you never have to show up and you never even have to give your name. At the application, you have to identify who you are to make sure you're qualified, but you never have to show. Send it in, fill out the right form, over.
So suppose in a case otherwise similar, two people, Johnston and Mittman in this case, developed, created, discovered the information. And one of them, Johnston, mails it to the commission. Is Mittman cut out?
Yes, for only one reason. You do have to fill out the form and send it to the commission. The commission does have the discretion to waive that requirement, and they have done it where justice so requires. So I would think in that type of case, they would probably waive. But you have to understand the way Congress and then when the SEC did their regs, you have to begin with this assumption. And in the first sentence of the legislative history on this law, original information. Then they carefully define it in the statute with the word means. Under digital, it's an absolute mandatory requirement, which means you have to be the one to develop it. You can see who they're trying to bring out, who they're trying to incentivize. Then, once you have it, you have to give it to the commission, either anonymously or in some manner. Then you have to prove that that information was a cause of sanction. Johnston did all.
Mr. Horn, I mean, was it impermissible for the SEC to conclude out of facts here that Mittman and Johnston were joint whistleblowers?
Absolutely. Their main piece of evidence.
I mean, your point is that they didn't jointly have original information, but it seems under the definition of whistleblower, the SEC was, it was certainly plausible to consider them as joint whistleblowers.
No. And the reason is, as I say, the definition of whistleblower includes two completely different classes of people. Those who present information can't retaliate. Those who present original information to the statute get an award. But more important.
But that's, the original information is not part of the definition of whistleblower.
But it is a requirement for a reward.
I understand that, but I'm just saying at the level of defining who the whistleblower is here, why couldn't the SEC conclude that Johnston and Mittman were joint whistleblowers?
Because, okay, a couple of reasons. Let's start with neither ever said they were in 10 years. That Mittman, when he applied for the award, totally disavowed it. He said, I'm an individual, and he refers to Johnston as his former colleague. Not one shred of paper in 10 years says joint. But it gets better than that, because the letter that's their primary evidence, an August 6, 2010 letter, where they talk about the team. If you read that letter, they don't say this is our formal complaint or this is our original information. What they say is we're preserving our rights, the rights of these three people. Then what happens is the SEC does its rules. Then Johnston asks his lawyer, contact the SEC. Do I have to do anything else? The answer is no. But what we know at the time is the SEC classified this case as under three different individuals and gave it three separate TCR numbers. And in the world of the SEC, this TCR is the big deal. That's how you're supposed to present your information. Three separate numbers. Then, when they apply for the award, both say they're filing individually. Where's the record that it's joint? But what was on the record is that Johnston was the only one who gave the original information, because in the application itself, approved by a lawyer for Mittman and Johnston, it said it straight up. It also said in that same application that Johnston was the one who presented the information. It's right in the application, and I can give you that site. It might take me a second to find it. So therefore, where's the evidence? Now, the other thing that, to me, that is really incredibly important evidence was the first affidavit by the SEC investigator. They know who giving the information. You're talking to them. She says, I know what Johnston gave. Yeah, because he gave it all, by the way. And I don't know what Mittman gave. She says that she has no idea what Mittman gave. But that's validated by all the affidavits, by the applications, because only Johnston presented it. And then what happened? Then she says, well, I'll call them joint whistleblowers, although I don't know what Mittman gave. That's erroneous. You just can't come up with a definition out of blue sky if you don't know what someone actually gave or if they met the definition. I want to say one other thing. I know my time is running low, but you're on a question, but which is, we raised this original information directly in our appeal, administratively. We had the right to fully augment. It's essentially a de novo appeal. We raised it clearly, but in their final order, the commission completely ignored the argument, which to us is the centerpiece of the entire law. They ignored the argument. They didn't even conclude that a joint whistleblower can somehow get around the original information requirement. They didn't even say that in their order. They don't even discuss it. I would say I know why they didn't say it, because Congress only wanted those with original information. You create exceptions to that requirement, and you will undermine the central reason Congress passed that law. Thank you very much.
Counsel for appellee.
Thank you, Your Honor. May it please the court, Stephen Yoder for the Securities and Exchange Commission. In its final order, the commission reasonably determined that Johnston and Mittman should be treated as a single whistleblower unit because substantial evidence in the record showed that they acted jointly in providing information to the commission.
Is that primarily because of they use the word team?
That is one piece of information that is recited in the commission's final order. I would point the court to the supplemental declaration of Olivia Zach that is in the record, and specifically to Exhibit A, which appears at JA 352. And I present this in distinction to what Mr. Cohn just presented. He pointed to JA 387, but if you look at 352, in the second paragraph, the first full sentence, counsel for both Johnston and Mittman writes, on July 26 and 27, 2010, Michael Johnston and Michael Mittman appeared with me at your offices in New York and voluntarily presented to the SEC a portion of the original research and independent analysis developed by the Johnston team pertaining to the Falcon and ASTA MAT funds. In that sentence, both Johnston and Mittman are described as presenting information at a single meeting together. That was sufficient evidence for the commission to discount what was said in the other letter cited by Mr. Cohn in his opening argument.
And this is by their lawyer on behalf of them?
Yes, this is by their lawyer on behalf of them. In addition, the supplemental Zach declaration also explains that at no point during this presentation or afterwards did either Johnston or Mittman delineate specifically which pieces of information had been developed or being presented on behalf of particular individuals. Based on the whistleblower definition, then, the commission treated Johnston and Mittman as a single whistleblower unit and went on to conclude that they jointly satisfied the award eligibility criteria, including the requirement that a whistleblower must provide original information. And here, I would point your honors, as Mr. Cohn did, to the definition of the definition of original information in Section 21F A3. That definition talks about original information being provided by a whistleblower. And so in that sense, it points back to the whistleblower definition appearing in subsection A6. And so the logically prior question is, who is the relevant whistleblower or whistleblower unit in this case. And that statute permits more than one person to qualify as a single whistleblower unit. And when those whistleblowers came into the commission and presented information, the commission thereafter essentially credited all of them, or I should say both of them, Johnston and Mittman, with all information provided by that whistleblower unit. At that point, ex ante, nobody knew exactly what would prove most useful to the commission. It would be equally the case, for example, that Mittman could have provided or originated the most useful information to the commission. In that case,
let me ask you, in this situation,
yes.
Are you suggesting that the affidavit referred to by appellant and the affidavit to which you refer on behalf of appellee are not in direct contradiction to each other, and therefore the commission couldn't simply ignore one without acknowledging the existence of the other, or at least somehow indicating that for particular reasons it gave more credit to one than another?
If Your Honor is talking about the affidavits that Johnston presented to the commission determined.
I'm talking about the way you set up the distinction. You said the commission could ignore the affidavit presented by appellant because there was this other affidavit, and you went on to describe it. And so I'm just asking, is that the proper way to look at the record here?
Well, Your Honor, I would point out that my colleague, Mr. Cohn, pointed to a letter. It was not actually an affidavit from their counsel. And I did not mean to imply that the commission could ignore the letter that was in the record. What I meant to say was that where there exists ambiguity in a record as to what the facts are, the commission is permitted to choose between competing accounts of the facts, so long as there's a substantial evidence supporting the commission's version. And in this case, the letters are not necessarily contradictory. The letter cited by Mr. Cohn says that Mr. Johnston made a presentation, but it doesn't say that only Mr. Johnston made a presentation. For example, if it said only or exclusively, then there would be a better argument for an outright contradiction here. But arguably, it's consistent with the other letter that was attached to the Olivia Zach declaration. And that letter said that both Johnston and Mittman had presented at this meeting in late July 2010.
Thank you for the clarification of your argument.
Sure, thank you, Your Honor, for pointing that out.
Mr. Yoder, is it the commission's position that they need to determine who the whistleblower is before determining the question of whether a whistleblower provided original information? I mean, that does seem to be part of the dispute between the two sides. Which question is prior?
Yes, Your Honor.
And I'm wondering, is it the commission's general practice to determine who the whistleblower is in every case first before addressing the second question?
That is the general practice in terms of how whistleblower award applications are analyzed. The logically prior question is always, does this person qualify as a whistleblower under the definition? And then do they meet the additional criteria specified in the statute to be eligible for an award? So that is the mode of analysis. This case was somewhat unusual in that there was a dispute as to whether one or both of these individuals should be treated as separate whistleblowers or as a single whistleblower unit. The commission reasonably read the statute's definition of whistleblower to permit them to be treated as a single unit because they had provided information together to the commission.
So what of the argument that Congress drew a distinction between who can apply and who actually can receive an award?
Are you asking, is there a distinction between who can apply and who can receive? I mean, certainly,
That's my question.
yes,
That's the argument that was presented.
yes.
Did
Anyone?
you not understand that?
No, I'm sorry. I had trouble hearing the audio, Your Honor. I apologize.
I'll speak louder.
Thank you. Anyone can apply for a whistleblower award. As described in the commission's brief, the practices of the commission is that once a commission action results in monetary sanctions of $1 million or more, the commission's office of the whistleblower posts what's called a notice of covered action on the commission's public website, inviting interested persons to apply for whistleblower awards in connection with that covered action. And pursuant to that process, anyone can submit a whistleblower application, regardless of whether they meet the whistleblower definition or the award eligibility criteria. But then the commission's office of the whistleblower takes those applications and processes them. And in the course of processing them, the initial question is, did this person actually meet the whistleblower definition?
So let me be clear of the process that you're describing. In other words, the commission's no longer involved. Once the filing is accepted by the commission by a person who claims to be a whistleblower, the commission proceeds on that assumption. So then when the award issue comes up, it's an administrative determination. I'm not clear that that was the nature of appellant counsel's
Yes, Your Honor.
argument.
I don't believe that the commission ever makes the assumption one way or the other that a person who applies is necessarily a whistleblower or not. Those applications come in, they're received and processed by the commission's office of the whistleblower.
But the way you were describing it, and this is just because I'm not familiar with the administrative process here.
Understood.
Suppose I apply.
Yes.
And we go through this whole proceeding and the commission's satisfied I'm a whistleblower. But then when the award comes up, it determines I've simply plagiarized somebody else's material. Does the administrative body say, well, doesn't matter, it was original by somebody and you're the one who's come before us and that's good enough? Or does it say, hey, you're no longer a whistleblower? That's not what is intended in the award. I mean, does that
Understood.
issue ever get back to the commission? Whereas here, as you point out, it's a little unusual because that issue came up at the very threshold.
Your Honor, one point of clarification here. At the time a whistleblower provides information to the commission does not make a determination at that time as to whether or not they meet the whistleblower definition. There is
What are you saying? You say I can apply, and at what point is the determination made whether, and as I understand it, there are at least two parts to the definition. And really, appellant is focusing on the second part, not the first part.
Your Honor, the commission does not make any determination at the time information is provided. But when the office of the whistleblower receives an application, and that can be from anyone, then a determination is made whether the applicant meets the statutory definition of a whistleblower. If the record is unclear, if there's a case of plagiarism, as you suggested, then the office of the whistleblower will work with the relevant enforcement staff who brought the covered action to talk to them about who provided information during the investigation and whether that information was helpful. And that's the point at which any plagiarism would be uncovered. And then the office of the whistleblower prepares an initial recommendation that goes to a body of staff called the claims review staff within the Division of Enforcement. They make a preliminary determination recommending how the commission should decide the award applications. Then that preliminary determination is given to the claimants, and they can request the underlying supporting documentation if they wish, and they're given an opportunity to respond. Then the office of the whistleblower prepares a second recommendation in light of those responses, presents that initially to the claims review staff, as a proposed final determination. And assuming that the claims review staff agrees, they then present that to the commission itself. And the commission, after considering it, issues a final order. So there was only one determination here by the commission as to whether or not these individuals were whistleblowers. That was at the final order stage. I hope that answers Your Honor's question.
Yes, thank you.
I'd like to take you back to something you said earlier, because I think I just lost the thread at the time. And that was the letter at 352 from the lawyer for the two claimants. And did you say, you pointed out that as between that and another document, there was not a contradiction?
Yes.
Because one of them didn't say that only Johnston presented information.
Correct.
And was that this letter at 352?
Yes, the one that did not say only was the one cited by Mr. Cohn at 387. That one at 387 talks about Mr. Johnston making a presentation, but it does not say that only Johnston made the presentation or that he did so exclusively. So that was the document I was referencing, Your Honor.
Well, this one seems to say, as I read this sentence, that both, quote, appeared with me at your offices and voluntarily presented to the SEC a portion of the original research and independent analysis developed by the Johnston team, which the Johnston and others had defined as including, I think, 3 people.
Yes.
So that's, I mean, it says, doesn't it? They both appeared and they both voluntarily presented.
Yes, Your Honor, I agree. I think the letter is clear on its face.
And then if we go to 387, what do we see there?
If you don't mind, I'll... Pardon me, Your Honor, I misspoke. It's 287, not 387.
There isn't 387.
My apologies. In 287, the first sentence of the letter was quoted by Mr. Cohn. He states, in response to your request following Michael Johnston's presentation.
Okay, and where is the request in question?
The request for information?
Well, it's in response to your request. What request? Where is that?
Yes, apparently at the July 26 and 27 meeting, after, as I understand the record here, after the presentation was made, discussions were had about a potential follow-up presentation to take place in August 2010. And I think it's those discussions, that's my understanding, Your Honor. Those discussions are referenced here by the word request.
So it was oral. The request was oral, is that what you're saying?
It was, yes, it would have been the commission's request, or I should say the staff of the commission's request.
And that was not in writing?
Not that I'm aware of. It's not in this record.
Because even this, if depending on the request, may be of no particular help to Mr. Johnston. I mean, if the request is in response to your request following Johnston's presentation. Well, if the request is, by the way, before Mittman spoke, I have a question about Johnston's presentation.
Right, and Your Honor, we just don't have that level of granular detail here.
Yeah, so I would say that the letter is of very limited value to Mr. Johnston.
I would agree, Your Honor.
Well, maybe he'll have information on the request to which it was responded.
Yes, exactly, Your Honor. And unless the court has further questions, the commission is prepared to rest on its brief. Thank you very much.
Thank you. So, counsel for intervener?
Yes, good morning, Your Honor. Justin Schur, on behalf of intervener Michael Mittman, may it please the court. The appellant's argument rests on inserting words into the definition of whistleblower that just aren't in the statute. What the appellant is arguing is that the court should analyze whether Mr. Mittman and Mr. Johnston jointly developed the original information, or whether they requested to be treated as joint whistleblower, or whether they actually ultimately submitted their whistleblower application jointly. Those words are not in the statute. All the whistleblower definition requires, Judge Ginsburg observed, is that the information be provided. And the record has ample evidence that they did so and supports the SEC as reasonable. The letter is one example. The supplemental affidavit of the staff member from the SEC specifically says, and this is Joint Appendix page 349, paragraph 5, where she says, in late July 2010, the Johnston team, in quotes, including Johnston and Mittman, identified a problem with the backtesting report, which meaningfully advanced the investigation. So the record is very clear that they provided the information jointly. But even if, for some reason, the court looks to whether Mr. Mittman himself was involved in developing the information, there is also evidence in the record that he did so. There's a report that in his whistleblower application, he references having prepared himself, or primarily himself, and that's called a volatility report. That is the backtesting report that appellant has identified as the primary source of original information. And that's on Joint Appendix page 182. In addition, there's also an email attached to that whistleblower application, Joint Appendix 228, where the counsel representing both Mr. Mittman and Mr. Johnston at the time presented that backtesting report. Again, it's called the volatility report. It said, this was prepared by my clients, plural, both clients. So even if the court were inclined to look at whether Mr. Mittman was himself involved in developing this information, the record supports that and supports the SEC's decision as reasonable. Now, the record does not have affidavits from Mr. Mittman or affidavits from his current counsel explaining all of this, because the administrative process at the SEC level did not allow for it. We did not know that Mr. Johnston was challenging Mr. Mittman's entitlement to a whistleblower. We did not see his affidavits addressing this. And so Mr. Johnston argues that this issue is uncontested in his brief. There's a reason, because we didn't know that this was an issue, and that's why the court isn't seeing his affidavit. So I just ask the court to keep that in mind when considering whether the SEC's decision is reasonable.
Was Mr. Arnold ever represented by Mr. Blumenfeld?
When they were providing the information to the SEC, yes, they were jointly represented by that.
All three.
Correct. And then later they were pulling out, and that's why they ended ultimately we're here today. One other argument that the appellant makes in the merits is that they didn't submit their whistleblower applications for the award jointly. There is no mechanism. Whistleblower application asked for a single name, but Mr. Johnston did his best to signal to the SEC that we are joint whistleblowers. If you look at Joint Appendix page 14, he essentially says, I'm submitting this application on behalf of my client. So if they could have that, that's essentially what they tried. Just briefly on jurisdiction, if I may, Your Honor, the statutory regime does not allow an appeal based on the amount. The SEC clarified that includes an appeal based on the allocation of.
Well, I don't think anything that's been argued here today drifts over into that concern about the amount.
Well, I think ultimately what Mr. Johnston is asking.
That's always, everybody's here because they want more money. Nobody's here to give it away or what have you.
Fair enough, Your Honor. But I think what the statute and the statutory regime intended was for a claimant who is denied an award come to this court and say, I should have been able to participate. The SEC got it wrong. It should not be read to allow claimant to come in and say that other claimant the SEC got it wrong in giving that other claimant. Because that suggests that somebody could come up, some member of the public would come to this court and say the SEC got it wrong about that stranger. Again, the only reason Mr. Johnston has
he has standing in terms of somebody else coming to.
Right, but the only reason Mr. Johnston has an argument that he has standing is because it affects the amount of his award. The SEC's decision was reasonable, and I ask.
All right, thank you. Counsel for appellant?
Yes, I would first just like to address the concern about who presented the information. And what's very important is when Johnston filed his original application, all three were represented by the same lawyer who had full primary responsibility for the case. Johnston had no idea that Mittman would file his own. So his application needs to be viewed in that light. But even in that light, in terms of presentation, JA 32, the Johnston Group arrived in New York. This is the July 26 office where Michael Johnston voluntarily provided sworn testimony to prevented new original information and independent analysis to the SEC. He breaks from using the team and they say Johnston. But they didn't even know Mittman was going to go behind their back, but they say it that way. But even more interesting is JA 67. Again, look what is stated here. Mr. Johnston's post-Dodd-Frank original information consisted of 6,391 pages of new independent analysis and his complete assistance, which was provided extensively to the SEC over 28 months. And then they go on. Mr. Johnston's post-Dodd-Frank original information did significantly contribute to the SEC's enforcement action. He's talking Johnston. I would even say if he said team, I could explain it because they didn't know what Mittman was up to. And remember, Mittman had access to this information. All this information before he filed on his own, braked with the group, and went in for his own money. In violation of all, we don't need to get into the other agreements, but what we'll say is this is very clear. And why this is so significant is because of the affidavit of the SEC investigator, Zach. There is no conflict between her two affidavits. In her second affidavit, she reaffirms all of the arguments and statements she made in her first affidavit. And this is where it really comes down to. This is the record which was ignored. These are facts which the commission ignored. And this is critical. This is the SEC investigator. So the way you have to understand this is the investigators interact with the whistleblowers, and in this case, for a period of years. They really know everything. Then it goes to claims review, and an independent group does it. But Zach's the one who worked with the whistleblowers, the whole team, for pretty much 5 years. Look what she says, uncontradicted. Well, we had significantly more contact with Michael Johnston.
What page are you reading?
We had no insight into how much Michael Mittman contributed to the materials. The application says it was all Johnston. The investigator who worked with them had no insight into Mittman. That supports the application. Then when Johnston saw the preliminary decision and realized the SEC got it wrong, he filed detailed affidavits. Now, Mittman says he couldn't file an affidavit. Absolutely not true. Anyone can file a statement to the SEC, augment the record on the basis of a preliminary determination. You don't have to be appealing it. Anyone can. It was right in the letter sent to everybody. Mittman knew he went behind Johnston's back. Mittman knew that he didn't give the original information on back tests. And Mittman knew that he never alleged joint whistleblower status. And he also knew, which we didn't have at the time, in his own application, it was individual, former colleagues. He knew all that. He easily had the opportunity to augment the record. He chose not.
Make sure I understand something. These references at 32 and 67?
Yeah, 32 and 54, I believe.
Well, you mentioned.
Or I might be wrong.
Oh, no, JA 54 is the internal page. 67 on the JA.
Oh.
This document is the application.
Correct.
So who wrote these words?
These words would have been written either by my firm or Mr. Blumenfeld.
Okay,
You will
so
see
this is
Blumenfeld
submitted on behalf of,
Johnston,
signed by
applied
Johnston.
individual.
So these are John, we can attribute these words to Johnston.
Correct. Your application must be filed under oath.
And at 67, you read to us Johnston's post-Dodd-Frank original information consisted of 6391 pages, right?
Yes.
That's Johnston speaking. And at 32, which you also cited, what's paragraph or what date is it?
Okay, that's 32, JA 32, the paragraph that begins with July 26, 2010 morning.
The Johnston group arrived, right?
Yes.
And there is a page here. Well, let's look at, for instance, 38. The Johnston group satisfies voluntary submission requirements. That's the group. Right? There's another point in here where the 6391 is referred to again. On one of these Roman numeral pages with a black box, you know what I'm talking about?
Your Honor.
There it is. I think it's 52.
JA 52?
Yeah. Middle bullet point. New original information included 6,391 pages of new independent analysis provided to the SEC. All Johnston Group original information satisfies all whistleblower rules. So he's not claiming any uniquely individual proprietorship here, is it?
Your Honor, on
Everything is the group at this point.
Remember, this was filed as an individual application with Mr. Johnston when he thought that this team that had existed 10 years before Dodd-Frank was even passed, not joint whistleblowers, but a team that had its own structure. They were financial advisors who worked together. He gave this document to Mr. Mittman. Mr. Mittman had opportunity to weigh in on it. At the time he did it, he had no idea that he would have to separate his contributions with Mittman's. No idea whatsoever. But after we got the preliminary determination, we filed these detailed affidavits that did separate what happened in glorious detail. I mean, page after page.
It's understood as a jointly, I say everyone agrees that there was a time when there was some sort of agreement among the three members of the team as to the division of proceeds.
Exactly. And just so you know, and it's in the affidavit, going back to when they were working together financially, that division was predicated. You look at how much money each person contributed to the case, not the information, how much money. Johnston put up about $1 million. Mittman put up about 44,000.
Okay, but the division is much more, well, I don't know. Do we know what the division was in the agreement?
Yeah, as I said, is the working relationship of the team, and it's in one of the affidavits, Johnston's and probably Arnold's, the way the team had worked before Dodd-Frank was passed is they would look at how much money you put in. What was your skin in the game? It wasn't based on being joint. It wasn't based on the quality of your information. It was on money.
So does that mean that did Arnold put in any money?
Yeah, he put in money, and Johnston paid, like, I think 92%. It's in the affidavit. And that was the understanding. It would be a simple rule of thumb. Johnston was in charge of the team. Arnold says he was the whistleblower. He had the original information. The lawyer for all three says Johnston discovered it. Johnston presented it. So if you're dividing contribution by original information, it's all Johnston.
I read from a letter from the lawyer, Blumenfeld, that said flat out, Johnston and Mittman went to the SEC and presented the information.
Correct. And that brings you to the other point. And I believe counsel for Mr. Mittman said so. At the time, no one knew what would be classified as original information according to the statute.
No,
3 requirements.
Wait a minute. You've maintained that only Johnston made the presentation. Blumenfeld's letter is to the contrary.
Because they were thinking in terms of the team. It was not done to differentiate. And the presentation we're talking about here is the presentation on the back test, which is the only presentation that is relevant. And the affidavits filed on the record, which were ignored completely by the SEC, make that point very clear. And what those affidavits lead to a conclusion is that the SEC is giving $13.5 million to a person who provided no original information as defined under the statute.
I have your point on that. Thank you.
All right, counsel, any further clarification in response?
Just one thing very quickly. They said that the SEC doesn't determine whether you're a whistleblower until they review the applications. That is not correct. You become a whistleblower the moment you give information to the SEC because you're protected from retaliation. As I say, the definition of whistleblower has 2 distinct meanings. So Mittman was a whistleblower. The moment he walked into that door, he became a whistleblower. But that doesn't mean you're entitled to an award. You're entitled to an award. It's a separate criteria predicated on original information. And I would view only a strict application of that rule. You cannot let the commission just wander about. They have to give the money to precisely who Congress wanted to get a financial incentive as opposed to being protected from being fired or black. So I want to thank you. I see I've gone over my time. I want to thank you very much for this opportunity. Thank you.
Thank you. We'll take the case under advisement. Courtroom deputy, please call the next case.
Case number 21-5282, CSL Plasma Inc. et al., appellants versus United States Customs and Border Protection, and Chris Magnus, Commissioner, U.S. Customs and Border Protection. Mr. Weiss for the appellants, Mr. Yellen for the appellates.
Good morning. Counsel, you may proceed.
Thank you, Your Honor. Baruch Weiss from Arnold and Porter, representing the Plasma Collection Centers, CSL Baring and Griffles. These are international companies with subsidiaries in the U.S. that have set up these collection centers throughout the United States, but especially on the Mexican border. The court knows we are here to appeal the decision of the district court, which dismissed our complaint on zone of interest grounds. The plasma collection centers had filed a complaint challenging the plasma collection ban that had been implemented by CBP back in June, a ban which had significantly exacerbated the already pre-existing pandemic shortage of blood plasma in this country. And the judge below dismissed the case on zone of interest grounds, finding that only American workers, but not American businesses, fell within the zone of interest. And since we were an American business, we could not bring this complaint. That is not the issue before this court. The reason it is not the issue before this court is on appeal, the government has conceded what it did not concede below, which is that some American businesses do fall within the zone of interest of the B1 statutory provision of the Immigration and Nationality Act. And we, of course, are a business. So the issue now before the court is whether we, our businesses, fall within the zone of interest or not. More specifically, the government's position is that not every business falls within the zone of interest, but you have to be a business with an international nexus. And And so the issue on appeal, which is now different than the issue before the district court, is whether or not to fall within the zone of interest such that you could bring a lawsuit challenging this ban. If you're a business, do you have to demonstrate an international nexus, or can any business bring this kind of lawsuit to challenge this sort of plasma collection ban?
Mr. Weiss, do we have to determine that any business could challenge this type of ban? I mean, even if we reject the government's sort of narrow international nexus test, is the only other alternative for us to conclude that any business can challenge this?
No, I don't think we'd have to say that any business can. In this case, I think it's easy if you part with the international nexus, then I think it's very easy to say on the facts of this case, these businesses can bring this down. These businesses have invested millions and millions of dollars at the border to collect plasma from Mexican donors who cross the border and have been crossing the borders for decades to donate as part of a procedure by which they get the funds. And we, by the way, disagree with the factual conclusion the government draws that we lack an international nexus. Our view is that an international nexus is not required, that we have a very sufficient stake to meet the zone of interest and the alignment of interest that the Supreme Court talks about in Pachak. We also say that even if the court were to disagree with it, and even if the court were to adopt the position of the government, we have the international nexus that is required. I don't think the court has to reach the question of whether, say, a business far away from the border in North Dakota that lost a sale of a candy bar because a Mexican was not allowed in would have the zone of interest that would be appropriate. So I don't think you have to reach that question. I think we're an easy case once you dispense with the international nexus, given the huge amount of money, expenditure, employment, effort that they put in to collect plasma.
So is your argument in part that as to that legal question, there are no disputed facts, so there's no reason to send this back to the district court? Because normally, if the government has conceded something, but it says there's another ground for affirming, the court might get to that.
Understanding
that issue.
The government said that even if it loses on the zone of interest, you could affirm on the merits. That was the argument that the government made in its appellate brief. What I'm suggesting to the court today is the issue, we're only focusing for a moment on the zone of interest, not even reaching the merits, which the court said you could reach on appeal. There is a pure legal issue, and the pure legal issue is this. When Congress used the word business in the relevant statute, in the B1 statutory provision of the Immigration and Nationality Act, when Congress said business, did it mean business? Or did it mean, well, business except if it has an international nexus? That's a purely legal question, Your Honor, which I think you could determine on appeal, and there's no need to remand to the district court to determine that purely legal question. And that is a question which we think is easily answered with the answer that business means exactly what you think it means. It does not have this different, special, unusual meaning that is imposed on it by the government. And we say that, yes, Ron?
So are you saying then that if we agreed with you that assuming such a nexus is required, you meet that, in other words, the import of the word business does not carry along, and if it does, you meet the requirement?
Yes.
But that could be the predicate for deciding not just that you are within the zone of interest, but rather that merits are to be resolved?
Well, that is a good question, Your Honor. Normally, the zone of interest analysis and the merits are two entirely separate analyses. And they were entirely separate in the district court. In the district court, the analysis was on the zone of interest, is it just American laborers or workers who could buy? And on the merits, the discussion didn't focus so much on the word business. It focused on a different word in the statute, on the word labor. The statute says you can come in for business unless it's labor. the statute says we want to open our doors for business, but we want to protect at the same time our local workers. And so in the district court, those were two distinct arguments. We talked about American workers as whether they can bring a lawsuit was the zone of interest. And then we talked about the question of whether donating plasma is labor on the part of Mexican donors. We said, it's preposterous. It's not labor that you sit in a chair. The labor is done by the employees of the collection center who take it. But now on appeal, I think you're right, Your Honor, there is a convergence of the two normally distinct principles. The zone of interest, which takes up the question of whether or what does business mean, is also an important question in determining, once we bring this lawsuit, once we're allowed to bring this lawsuit, whether on the merits the government is right or wrong. And so there is
the merits of what? The merits of your motion for a preliminary injunction?
The legal merits of our interpretation of the Immigration and Nationality Act, which is a predicate for the preliminary injunction. Now,
So you have other showings to make.
Yes,
Correct.
yes. If we want a preliminary injunction, we have to show public interest, which we think we've shown, given the shortage of it, that it's exacerbated and the desperate need.
But you also have to show a probability of success on the merits, and that's where this would tend to overlap.
That's exactly right. Yes, Your Honor. That's where it would overlap. So, for example, if you were to rule that business means what Congress said it was, and Congress just used the word business, the regulation said it means activities of a commercial or professional nature. We think this is of a commercial nature because the Mexican comes in to donate for the $50. That sounds like very much a commercial transaction. I don't think the government contests that. I'm sure the government does not contest that. So if you reject their effort to inject the international nexus element here, then you've already disposed of a significant chunk of the merits. And when I say merits, I mean the interpretation of the Immigration and Nationality Act provision that's central to this case.
As it bears on your application.
Correct. Now, there are other parts of that statute that need to be interpreted too, when it makes an exception for labor, when it says business can come in, but not if you're going to engage in labor. When CBP announced the plasma collection ban, they didn't rely on the word business, they relied on the word labor. And they said, oh, these are laborers, and they're coming in to engage in employment and labor in the United States by donating their blood. The government on appeal does not claim that that interpretation ties into the zone of interest test. So that would be an analysis that would be done on the merits. The government claims that it's the business word that serves as the operative gatekeeper in determining the zone of interest. And so that's why I'm addressing my argument to government, to business, but I'm happy to talk about labor too, because the statute says business, yes, labor, no. And we think we are business. We think we are not labor, and therefore that we fit squarely in the terms of the statute.
I will ask this to the government lawyer as well, but I mean, are there any other places, where does the government find this international nexus test? I mean, is it just in this litigation? Is it in any other regulations?
Yes. So I want to address that. Let me, if the court will permit me, I want to first talk about where it's not found in order to show where it is found. It's not found in the statute. The statute doesn't say it. It's not found in the regulation when the regulation talks about business. The regulation, I'll say, and parenthetically, does use the word local in describing the labor component. There's no geographical qualifier with respect to business. The regulation says business means an activity of a professional or commercial nature. Then when it says not labor, it says labor means local employment or labor for hire. So in our view, and this is going to answer your question, Your Honor, in a moment, in our view, there is no geographical analysis or international nexus analysis needed when you're looking at business. Statute doesn't do it, the regulation doesn't. In some cases, but not all, the particular business may implicate labor. Sometimes people come in to engage in business that's not qualified. Some instances, yes, labor, in some instances, you can't tell. If it is labor or possibly labor, then you have to determine whether it's local labor under the regulation, because not all labor is prohibited, only local labor, but not international labor. So the international comes when the cases that deal with individuals who are coming to the United States under a B-1 business visa are engaging in something that looks a lot or might be labor, and then the cases say, well, this is labor, is it excluded? But not all types of labor are excluded. It has to be local labor to be excluded. And we see this business seems to be an international business, so therefore the labor done with the business really can't be characterized as local labor.
And those are judicial opinions?
Those are mostly BIA cases. Those are mostly BIA cases. And so when they get caught up in talking about international is when they're grappling with the very specific instance when you have business and labor. And since only certain types of labor prevent a barrier to qualifying to a B1, only local labor, that launches those cases into an analysis of whether it's international. So for example, they ask the question, what if you're a bus driver or train conductor going from Canada to the United States? You're engaged in labor, but is that local labor? And they say, well, it's part of an international business, so it doesn't seem like local. And you find that analysis time and time again.
But that's not to say, and I don't suppose that BIA says that, therefore, if it's non-local labor, it has to be internationally non-local.
Correct. It doesn't, but what it does, you're right, but what it does say, oh, but we're looking at the labor here and it happens to be international and therefore it's not local.
Right, but that's a little bit of a gap.
Correct.
Differential gap.
Correct. But there is a lot of language in the BIA cases, oh, this is international, or this is international, and therefore the B1 is okay. And that is where the government's mistake comes from. The government, the geographical limitation is articulated only by the word local and only in conjunction with the word labor. The cases, the BIA cases, therefore look at cases, is this local or international? And they say it's international, therefore there's no bar to a B1 visa. And then the government reads those cases as saying, there has to be an international nexus. That's where it comes from.
And what are the BIA cases to us?
What are the BIA cases to you? Well, the government,
informative, perhaps?
The government, at some point, I think, tries to argue that they're entitled to a certain amount of deference. In this case, I don't think so. I mean, these are pure determinations of law. They are not like promulgating a regulation, for example. So the government cites them. I don't criticize the government for citing them. I might criticize the government for misinterpreting them.
So why is the case raising a similar issue before the BIA rather than the district court?
Why does it? Well, the BIA will typically get a case when it's determining a case of a particular alien who's challenging something that's being done with his visa, like an exclusion proceeding. But here, we are representing American subsidiaries of these international businesses, and our remedy is to challenge it under the APA in court. I might add, of course, the court needs to take in mind, which the court knows, the very pro-plaintiff zone of interest standard. In other words, we have to be arguably right. The Supreme Court said that. Arguably, it's presumptively reviewable. The benefit, this is all language from the court, the benefit of the doubt goes to the plaintiff here. It is not designed to keep cases from being reviewed. And I would add that, by the way, an adverse ruling to, and then there's the language of the APA, which says, are you adversely aggrieved? Are you aggrieved or adversely affected? Excuse me. We are aggrieved and adversely affected. This has caused us a significant loss of business and a significant inability to live up to the requirements that we have in terms of the blood plasma supply, which there was a very serious shortage resulting from the pandemic. It was about a 20% decline because of the pandemic. And this has now come and exacerbated. This is yet another shortage on top of the prior shortage.
Do we know whether the employees of your clients have been laid off as a result of the ban?
So I do know the answer to that, Your Honor. And the reason I know that the answer to that is after Judge Chutkan dismissed our case and we appealed to this court, reading her opinion, we filed another complaint with plaintiffs who are individuals, which include employees of the plasma collection centers, include donors, individual donors. In other words, she said it was individuals, and we found individuals who were very interested in challenging plasma collection ban, and we brought a second lawsuit. And what
So the consequence of the plasma ban and the court's decision together is to disemploy American workers.
correct. There are many American workers. We are going
This
to
is a
have,
protection that they didn't really need.
correct. Yes. Correct. We have, as part of the record there to demonstrate standing and so on, we've explained how because the Mexicans are such a significant percentage of the donors that we may have to close down a significant number of the sites and lay off a significant number of the workers. And so what has this plasma ban done? It's hurt us from a public health perspective. It's hurt us from an employment perspective. It's hurt us from an economic perspective because the Mexicans who cross the border would get this $50 and they would, for the $50, they would make purchases on the American side of the border. And it has significantly hurt the economies of the border communities where
Well, they don't have standing.
they're not part of this lawsuit. That's not an issue that you have to reach. But it is relevant, Your Honor, on the preliminary injunction when you consider the public interest in the issuance of an injunction.
You'll have to take that to the district.
Correct. But I'm saying it's not entirely relevant to the case. It may be irrelevant to the issuance to this particular. I see that I've run out of time. I was going to catalog all the other reasons why there is no international nexus.
Are they all in your brief?
You can rely on the brief, or I still have 3 minutes. Maybe I'll have an opportunity to address that on that. Thank you.
All right, we'll hear counsel for appellate.
Good morning, Your Honors. May it please the court. I'm Louis Yellen from the Department of Justice. I'm here today on behalf of U.S. Customs and Border Protection.
You're welcome to remove your mask if you want.
Thank you, Your Honor. If it's okay with the court, I'll retain it.
As long as we can hear you.
Yes, Your Honor. If you have trouble, please, of course, do let me know. There are three issues that came up in the court's colloquy with the plasma company's counsel that I'd like to address. The focus of the inquiry, whose activity is at issue, the question that Judge Rao asked about the basis of the international nexus test, and the deference point that the court asked. To begin, the focus of the inquiry in determining whose activity is relevant is the non-citizen. The statute authorizes visas for non-citizens visiting the United States temporarily for business. So the question is whether or not it's the alien who is engaging in business, not whether or not a third party down the line has some international business, but whether the alien, him or herself, is engaging in business.
So
Now-
if the counsel for the appellants is correct that there's a commercial transaction here, then both are engaged in business.
Then, I'm sorry, Your Honor?
Then both parties to a commercial transaction are engaged in business.
We're not disputing that it's a commercial transaction, Your Honor. The question is whether or not that transaction has a connection to international.
Okay, so you're saying it's business.
It's business,
Okay,
but
I
it's
didn't-
not
okay.
international.
Gotcha.
Yes, Your Honor.
Okay.
Now, the reason that we know that it's the employee, or excuse me, the alien, the non-citizen's activity, that's the focus. The matter of G case from the Board of Immigration Appeals, which we cite at 40, I think provides a very clear example. Because in that case, the Canadian company, the employer, was unambiguously engaged in international commerce. Yet the board held that the non-citizen's activity was not business for purposes of the B1 statute. I can explain some of the
I'm sorry,
details.
and which case was that? What was the?
Matter of G at page 40 of our
Right, so what
brief.
was that person doing?
So this was an employee of Ford Canada who lived in
Oh,
Canada.
yeah, so he had a job.
He had a job.
Yeah, he's laboring.
But again, Your Honor, the reason that this case is important is it demonstrates that the focus is on the non-citizen's activity, not the company's activity.
That's clear. Okay, I mean, in the sense that you have to enter to qualify for the B visa, right?
But the question I'm trying to address, Your Honor, is whether or not the non-citizen's activity must be international or whether the companies is sufficient.
Okay. Good.
Opposing counsel referred to the fact that the companies are international, engage in
So
international commerce.
there's a case involving the sale of vegetables, right?
Yes, Your Honor.
So
And
the vegetables are grown across the border, brought in and sold, and the person and their proceeds go home.
yes, Your Honor.
How is that different than coming here, selling the plasma and going home?
The difference, Your Honor,
Same day.
the difference, Your Honor, is that there's a commercial undertaking in Mexico or in Canada. That is, in all of the cases in which the Board of Immigration Appeals held that that activity was incident to international commerce, the board determined that most of the employment was in Canada, that there was a commercial activity in Canada, and that the activity in the United States was the non-citizen's extension of that commercial activity across the border. In the case of donors of plasma, sellers of plasma, the sellers of plasma are not engaged in a commercial activity in Mexico with regard to the plasma. They don't have a business selling plasma. They just come to the United States and they sell their plasma here. That's the only commercial activity.
Is that different from growing vegetables, say, in your own personal garden? Right? I mean, your body produces plasma. Maybe you grow zucchinis in your garden. In both instances, you take them across the border and sell them.
There is no case that's held that this example of growing vegetables in your garden would be sufficient, and it would be inconsistent with the board decisions to say that that would be sufficient.
So maybe take a step away from the BIA decisions and can you tell me, based on the statute and the regulations, where this international nexus test comes from, where the business has to have an international nexus?
I certainly will, Your Honor. Let me preface my answer by saying the Supreme Court has recognized in Aguirre that the Board, of Immigration Appeals interpretations of the statute are entitled to Chevron deference. So at least as a merits question, the board's interpretations actually do govern here. But responding...
Well, they govern here if the statute is ambiguous. I mean, Chevron deference doesn't mean we just defer to the BIA.
Since 1929 in the Carnot statute, the Supreme Court has recognized that the term business is ambiguous. It deferred to applicable regulations interpreting that statute. Similarly here...
Different statute.
I beg your pardon, Your Honor. Yes, exactly right. The predecessor to this, it had the same relevant language. It's the origin of the statute that is at issue in this case. But now directly answering Your Honor's question, you can tell from the context of the statute itself that the activity in B1 is not purely domestic commercial activity. It has to be. There are numerous other provisions in 1101A15 that highly regulate domestic business activity. And if business meant anything other than labor, as opposing counsel suggests, all of these provisions would be superfluous. We cite them on page 28. I'm happy to go through any of them, but if I might point out one that's of particular salience.
Can I just ask you a preliminary question? The way you
Yes, Your Honor.
describe the BAIA cases in Canada and Mexico, as I understood your explanation, you said most of the company's activity is not international, suggesting to me that, well, that isn't a disqualifying requirement.
Your Honor, if I said that, I misspoke. The point
What did
of
they
the
say?
BIA,
It has to be?
they said that the non-citizens activity had to be international. That is, the focus was on the status of the non-citizens activity.
I know, but what I'm trying to understand is we have this statute and somebody who otherwise lives in Mexico has an opportunity only to come to this country to give us blood and then gets paid for it and goes home. So you're saying even the association with a commercial activity in this country is not enough because the farmer or the Mexican citizen is not bringing his own vegetables in. He's latching on to a company's activity in this country that also has international aspects. Has the BIA ever dealt with that kind of situation?
Yes, Your Honor. The matter of G case I previously referenced.
I know that's the Canadian case, all right? And I understand the distinction, but I'm not sure. I mean, you likely read it more carefully than I, but I didn't understand them to say, absent that, you know, it wasn't as hard and fast a rule. Maybe I misunderstood.
I'm sorry, Your Honor. There is not a Board of Immigration Appeals case which holds that the alien non-citizens' conduct in the United States is B1 conduct in virtue solely of the company's international activities.
So the BIA has not decided that question?
No, the BIA, quite the reverse, has held that it must be the non-citizens' conduct in the United States that must be a necessary incident of international commerce, that this is the G case.
No, but I understand that. But another way of looking at the facts here would be that, and I'm not saying this is the way the BIA would do it, but I just want to be clear about it, is the only reason a Mexican person is coming for this short period of time is to engage in a commercial activity of a US business.
That's right, Your Honor. It's to get paid by a US business. And the relevant question under B1 is whether getting paid for the activity that the Mexican national is undertaking in the United States is business within the meaning of the statute at issue here.
No, I understand that, but I'm just trying to be clear that when Congress was talking about all of these other interests it was protecting, I mean, arguably any US citizen could contribute plasma too, but they're not interested in doing so apparently for the amount of money this company is willing to pay. But there are other people who are. So the only way for this company to avoid a problem is to set up a center in Mexico?
Your Honor, there might be other avenues that are available. The only
well,
thing
for example, if it set up centers in Mexico.
I think there might be legal impediments to that in Mexico. I believe that selling plasma in Mexico is not permitted. That is commercially selling
so this
plasma.
Company simply can't deal in North America.
No, Your Honor. The only question is whether the current visa permits this sort of activity. We're not taking a position on whether there are other mechanisms by which Mexican nationals could come into the United States. The only question that we're addressing is whether this particular visa provision authorizes that.
No, I understand that, but I'm just trying to understand how, I mean, this is such an odd situation. And that's what I'm trying to understand the agency's position, much less the government's position on appeal as opposed to where it was in the district court. And, you know, that almost makes me say, well, let's send it back to the district court and let it sort all of this out.
Respectfully, Your Honor, and I could address this in a moment, the government's position did not radically change in the way that plasma company counsels suggested.
Well, I think you haven't contested the fact that you have taken a different position, at least in part. I didn't think that was a dispute.
Your Honor, we only had one filing in the district court, and that filing
I don't care how many filings, but the point is you made one representation in the district court, and your brief before us has qualified that somewhat. I didn't think that was in dispute.
I think it's not critical, Your Honor. Respectfully, that's not how we view our filing below, but I don't think.
Well, let me put it this way. Reading the district court's opinion, I didn't see any indication that she thought that argument was before her. Now, maybe I'm wrong.
That may well be true, Your Honor. If I might get back to the subsection that I thought was helpful in
yes.
I have a question, Mr. Allen. I mean,
Could I just have him finish?
I'm sorry.
I'm sorry, Your Honor, I didn't.
Or
I'm
was
sorry.
he finished?
I was finished, Judge Rogers, unless you had further question for me. I
No, I
apologize.
thought you wanted to get back to the subsection. Did you have something else to
Oh,
argue?
I did. This
If
was in
not,
response
then
to Judge Rao's
Rao, please
earlier.
proceed.
Thank you, Your Honor. Would you like me to refer to that, or do you want me to take your question now, Judge Rao?
I guess I'm wondering if you disagree with Mr. Weiss's characterizations of the BIA decisions. He suggests that the international component has been discussed in the BIA opinions with respect to labor, not with respect to business. And so I'm wondering, I am not an expert in BIA decisions in this area. Maybe I will have to become one, but I'm wondering how you would characterize that.
I think that is plainly incorrect, Your Honor. I would suggest the court look at the Wangara decision. It was a Third Circuit decision analyzing a BIA decision, which involved a company that was created by a Kenyan national who was selling goods in the United States. The Neal decision involved an engineer providing engineering services in the United States. These are all things that could be classified as business in a broad sense. Getting back to the statutory question, though, that Judge Rao asked earlier, if the court looked at A15E, A15E is a provision that authorizes a visa for someone to come, a non-citizen, to come to the United States to develop or direct the operations of an enterprise in which the non-citizen has substantially invested. But there's a qualification. That activity is permitted only if there's a reciprocal treaty between the United States and the foreign state of that non-citizen's nationality, permitting that business activity. If business meant what the Plasma Company Council says it meant, then that same non-citizen could come in under a B visa and engage in that very activity without the qualification. Now, this is true of all of the provisions that we cite at page 28 of our brief. All of those provisions would be rendered entirely superfluous if business meant any sort of business whatsoever. Those are all activities involving domestic commercial conduct, which Congress has heavily regulated and provided prerequisites for. And for that reason, because Congress has heavily regulated and identified the types of domestic commercial activity in which non-citizens may engage in the United States, business in the B1 provision refers to business activity, commercial activity having some international connection. Now, on the merits, the board decisions are absolutely clear on this point. They talk about the need for the non-citizen's activity to be have a necessary incident to international commercial activity. The HERA case, which is a canonical case identifying this, interprets the State Department's regulation and the statute and says that the activity must be a necessary incident. The Neal case does the same. The G case, every single one of the cases that we have cited and that opposing counsel has cited refer to the need for the activity that is the non-citizen's activity to have a necessary connection to international commerce.
Did I understand your answer to Judge Rao earlier about the vegetable garden and the owner bringing the vegetables for sale in the U.S., but that didn't qualify because that wasn't the vegetable gardener's business?
Correct, because the vegetable gardener was doing that as, I'm assuming in this is built into the hypothetical, was doing it either as a hobby in Mexico or doing it purposely to raise crops and sell them only in the United States. In the farmer cases...
Let's just assume not that it's a family plot and they sell locally in Mexico and then they also sell in the U.S. at a better price, perhaps?
That would likely be permissible, Judge. If you look at the K and B case, which the Plasma Company cite in their reply brief, that would be permissible if the predominant commercial activity occurs in Mexico.
But where'd the predominance requirement come from?
This is how the board has interpreted the term business. The board has said that for it to be international commerce, the majority of the work, the majority of the commercial activity has to be in the foreign state. And the activity in the United States has to relate to that foreign commercial activity, but it cannot be the predominant activity, that is the commercial activity in the US. This is exactly why the Third Circuit case, the BIA held that the non-citizen was not engaged in international commerce because there was not the international component. That is, there was not a Kenyan business anymore to which the commercial activity in the United States related. In all of the farmer cases, there are also cases involving the collection of scrap paper, cases involving the collection of firewood. In each of these cases, the board has determined that the predominant commercial activity was in Canada or Mexico, and that the US activity was incident to that foreign commercial activity.
I think earlier you said necessarily incident.
The board has determined that the conduct, the phrase the board uses, is a necessary incident to international commerce.
Well, why is it necessary? I mean, if you couldn't sell them here, you'd have to sell them at a lower price abroad.
You're right, Your Honor. No, I think that focuses on the wrong question with respect. The question is whether the activity here is related in a necessary way to some form of international commerce. So just to give one example.
Well, it's related. I don't understand how it's necessary.
Well, if I might give just one example, there are cases involving transportation of automobiles from Canada to the United States.
Right.
The board held that unloading those automobiles is a necessary incident to the commercial activity of transporting them across the United States, across the international boundary.
Isn't that a question about labor, however, whether that person was performing labor?
So labor, first I should say the regulatory term is local employment or labor for hire. That's a term of art. There's business on the one hand and local employment or labor for hire on the other hand. And if activity is permissible under B1, it qualifies as business, regardless of a colloquial use of the term. That is, it could involve labor. In fact, many of the cases do involve what we would commonly call labor, like truck transportation, loading and unloading, and so forth. Conversely, local employment or labor for hire is all of the impermissible activities. But that could include things that we do not colloquially call labor. For example, engineering, providing engineering services. It's a form, to use the statutory term, of skilled labor. But to be clear, these are terms of art. And I think it's quite important that the court not just consider the colloquial uses, but focus on the way in which the Board of Immigration Appeals has interpreted those terms in light of the history of the statute and the regulations.
So, Mr. Allen, if we rejected the government's international nexus test, then do the appellants win? Because you've conceded, the government's conceded that business can be within the zone of interest. So with respect to this question before us, I mean, if we reject your test, do they, I guess, what is the government's, say, fact-specific reason why they are not within the zone of interest?
I think it's quite critical at this juncture to distinguish between the zone of interest and the merits question.
Mm-hmm.
If the court determined that there isn't an international connection requirement for the zone of interest, nevertheless, it's quite clear that the plaintiffs lose on the merits in light of the BIA's interpretations, which are entitled to this court's deference under Aguirre-Aguirre, that the activity of the non-citizen does have to have a necessary incident to international commerce.
Do you think we can split those things, that there could be a different test for what's like within the zone of interest test and on the merits?
Absolutely.
With respect to the meaning of a statutory term business?
Absolutely, Your Honor. The zone of interest test is a more general test than the merits test. The zone of interest test asks whether or not a particular plaintiff has a cause of action under a statute. That is, whether Congress intended for that plaintiff to be able to sue. But that's a different question from whether or not the plaintiff wins on the merits. The answer to that merits question is going to be more detailed of necessity. They're related. They're both merits questions involving an interpretation of the action under the statute. But the actual standard that applies is going to be more detailed. So it's quite possible that if a court determined that there isn't an international a connection requirement for the zone of interest, nevertheless, in light of the board's long 50-year plus interpretation of the term, the non-citizen has to have engaged in activity that is a necessary incident to international law.
So, Mr. Gill, my memory may be failing me here, but I'm trying to recall of a case in which Chevron deference was invoked on behalf of an agency not involved in the case.
Your Honor may be thinking of the Rappaport case in which there were multiple agencies that administered a decision. Is that what?
Well, if there's multiple agencies, I don't think there's any Chevron deference, correct?
Well, in that case, the court so held.
Yeah,
but the court made.
But here you're asking us to defer to a position that the BIA has taken in other cases that are factually analogous, but not the same as this case. And we don't know out of their own mouths what they would say about this case. And you're asking us to defer to a sort of general principle of that.
With respect, Your Honor, it's not a general principle. It's a principle that is directly derived from each of the BIA cases. If it's the case that the board has held that to come within...
I'll take that point and still ask, are you familiar with any case in which the court has deferred to an agency's position when the agency isn't before the court?
I'm not off the top of my head. I can certainly look to see if there are any and inform the court.
However, we're in the same spot there. Well, it counts either.
But with respect, Your Honor, the board's interpretation of a statute is a binding interpretation of the statute regardless of its context. It doesn't have to be a party before the court for its interpretation to be afforded Chevron deference.
Well, that's the question. That's the question.
I'm aware of no legal requirement that would say that a court should not abide by an agency interpretation that's entitled to Chevron deference when the agency is not a party before the court, but should when the agency is a party before the court. That would lead to... The
closest thing I can recall was a case involving primary jurisdiction, a doctrine that's no longer taught in the schools, in which the question involved whether the employer responded in the case was covered by the railroad retirement system or the Social Security system, which depended upon the interpretation of interstate carrier in the Interstate Commerce Act. And the Surface Transportation Board was not here. It was only the Railroad Retirement Board. And we held up the case for the company to seek an opinion from the relevant agency. Is that where we are here?
I don't think so, Your Honor, because again, the principles that are quite explicit in the board cases apply in this case. If it is the case, let me just, if I might, try to connect the dots explicitly. If it is the case, as the government says, that the board has held that to be business within B1, the non-citizen must engage in activity that is a necessary incident to international commerce, then that principle applies of its own force and unambiguously to this case. Because
so here's my question. I understand the government's emphasis in terms of deference to the board, but is the government, I don't understand the government to be arguing that the board could not change its view in these circumstances involving, a public health emergency, US citizens are dying. I don't know, maybe the board would stick with it and say it's up to Congress, but as I understand it, your argument is simply, these other, what I'll call more typical activities with people who come into the United States and deal with a company that's here But this is not exactly different. And I mean, it is different. And you're asking us to apply, I think, a general principle, but who knows what the board might do in this case, and maybe it would stick where it is, but clearly this sort of public health emergency has caused all kinds of changes, and maybe you have to go back to Congress to get them, but I want to be clear how far the government's argument is taking it.
Well, I guess I
think
have
Judge Rao's questions keep going to show me something in the statute, at least some of her questions. And your response is, well, you know, you owe deference to the BIA, even though it hasn't dealt precisely with this fact situation. But there's, you know, a principle that applies, and that's the end of it. And so even if we were to adopt your position, is it your position that we could necessarily not hold that the BIA could not reach another decision? And that's sort of the hold in abeyance notion that was just floated.
So a few thoughts in response, Your Honor. First, there's not a mechanism to send this question to the BIA.
Well, that's for the court to decide, isn't it, at this point? I just want to know what the government's position is. Is it that the BIA, even if the company were to go before it tomorrow, could not reach a different conclusion in the fact situation? Or, you know, it might just stick to its guns and that's it. But we don't know.
So what I would say, Your Honor, is it would be inconsistent with 50 years of BIA jurisprudence.
Well, so is this pandemic. I mean, when was the last pandemic that we had? It's more than 50 years ago.
Your Honor, respectfully, the reason why this case is so different than others is because these particular individuals are not engaged in what's recognized as international commercial activity.
I understand that, counsel. But you won't give me a yes or no answer, I gather, so I'm not going to pursue this.
Well, I can't give you a yes or no answer, Your Honor, because there's not a mechanism for getting a question like this before the BIA. So the court is...
Well, that's a legal conclusion, isn't it, counsel?
Yes, Your Honor, but respectfully...
It's not briefed.
It's not briefed. No party has addressed it.
No one has cited anything. So, you know, moving on from that, if we can't hold it in abeyance to give the company or maybe some of its employees and the patients who have filed another case before the district court could pursue it before the BIA, we don't know.
Your Honor, the BIA hears cases involving the exclusion or inadmissibility of non-citizens. It does not.
I get that, counsel, believe me. All right, I get your point, but let's move on.
I just had one other question. I mean,
yes,
since the BIA, as you mentioned, and we know, does do these individual adjudications, are BIA decisions binding on this type of litigation where a party has challenged a general policy of a federal agency?
I think the questions of law are, Your Honor. I think they do deserve deference. And I would say I did not...
You think they do, but are there cases that suggest that the BIA determinations deserve deference in this type of context, not in the context of another determination of a of an alien challenging some admissions decision?
I think this is related to Judge Ginsburg's question, and I'm not aware of cases addressing this one way or the other. What I would say as a matter of first principles is it would lead to somewhat potentially contradictory results if the BIA received deference on an interpretation of law in one context, but not in another context.
The contexts are very different. I mean, does the BIA have rulemaking authority?
No, Your Honor. The court has held a bigger part.
It doesn't have rulemaking authority.
No, but it has adjudicative authority. And the Supreme Court has held in Aguirre that the BIA's interpretations of the INA receive Chevron deference in its resolution. in its articulation of the law, in its adjudications. And
Counsel,
those-
the Supreme Court has clearly recognized that an agency can change its interpretation and it can explain why and give reasons. So that's just not an answer. And that's what I think Judge Rao's question is trying to get you to understand and address. Just assume, but you want to fight this battle that no one's fighting right now.
I beg your Honor's pardon. I don't mean to be fighting any battle. I'm only suggesting that the court has the law that's before it. No party has sought an opinion from the BIA, nor is there a mechanism for doing so.
And I think that's repetitious. I think each judge has heard your answer. And I thought Judge Rao's question was trying to see if you were open to giving other than a repetitious response.
I beg your pardon, Your Honor.
Anything further?
No, Your Honor. I would just encourage the court to look closely at the board's decisions and consider the principles there. And we think that it leads to a fairly clear decision in this case.
Thank you. We'll take the case under advisement. So, counsel for appellate.
I would like to address a number of points that were raised by the government. One that stressed with some force that a non-citizen's activity must be international, or at least predominantly international. He said that is something, a requirement that comes from the BIA and needs to be imported into the statute and the regulation. I'd like to address that. And in addressing that, I think I'm also going to be able to address some of the deference questions that seem to be a different issue, but converge with this question. The best way to understand that position is incorrect is to look at the very specific examples that the government gives in its regulations and in the Foreign Affairs Manual of B1 qualifying cases. They give examples. Now, the government has said there has to be an international nexus, or at least a predominantly international nexus. If you look at the regs, 22 CFR 4131, the term business, it says, it defines it as used in the B1 statutory provision, refers to conventions. I don't see a convention necessarily having an international nexus. Conferences, consultation. So somebody comes into this country for a consult, a business consult. There is no requirement here in the definition section, in the examples that are given here, to indicate that there has to be an international nexus. Another example that the same regulation gives. The regulation gives an example of somebody who cannot come under a B1, a construction worker. That's the paradigmatic example of somebody who does not qualify B1. Why? Because although he's coming in for business, you're engaged in labor. But then the regulation says, but the supervisor of a construction worker can come in under a B1. Now, how does the supervisor of a construction site come in? It could be any construction site. It could be the treehouse in my backyard. If you're the supervisor and not the laborer, you can come in under the B1. What international nexus is that? And that's the regulation. Then you look at the Foreign Affairs Manual, the FAM, which is essentially the equivalent of a regulation. And this is what instructs the State Department. Here are some examples of B1 business visas, it says. It says, if you're coming in to consult with business associates, if you're coming in to play golf for prize money, where's the international nexus there? If you come in, professional athletes such as golfers and auto racers, if they're getting prize money, can come in, even though they're getting the prize money, under B1. If you're coming in to litigate, that's an example that the FAM gives. I don't see an international nexus. If you're coming in to undertake independent research, you get a B1. These are not my examples. These are the government's examples. These are what guide our consular officials as they decide whether or not to issue B1. If you come to participate in scientific, educational, professional, or business conventions, conferences, or seminars, these are some of the examples that they give. there is clearly no requirement of an international nexus in these examples. That then gets to the deference issue as well. Why? Because I don't read the cases clearly the way Mr. Yellen reads the cases. I read them the way we said before, that they introduce this international idea because they're dealing not purely with business, but business versus labor. And they're trying to find as the labor locally. But even if you were to accept his reading, then what you have is you have very inconsistent positions being taken by the government. The government, through the BIA, at least according to Mr. Yellen's reading, is saying there's an international nexus requirement. But the government is also saying through the regulations that the government promulgated and the FAM that the government promulgated, it's giving examples where there's clearly no international nexus. When you have those confusing messages from the government, I don't think they're confusing, but if you accept Mr. Yellen's reading, then it is clear that there is no Chevron deference, there's no Skidmore deference.
Why couldn't all of these occasions for entry be qualified under the case law of the BIA as requiring that international connection? So the supervisor can come in if the project is commissioned in Mexico or what have you, the litigation involves business affairs outside the United States.
That, Your Honor, when you look at the regulation, especially you're looking at the FAM, you were looking at something that's given to a non-lawyer who's a consular official, and he looks at the application and he says, oh, he's coming for a convention? Conventions are okay. That's it. What sort of guidance is that in the FAM if you're giving it to a consular official and you say, I'm not going to tell you this, but the most important requirement that we're not even going to write down is that you got to be sure there's an international nexus. So if somebody's coming to a conference on international law, you let him in. But if he's coming to a conference on New York law, for example, you can't let him in because there's no international nexus. I mean, the FAM is supposed to be an everyday easy guide for the consular officials to apply. When somebody comes with an application, they look at the application and they say, oh, this is what he's coming. I compare it to the list. He's okay.
The FAM, however, is not a regulation.
The FAM is not, but the FAM is an articulation of the government's
It's some
position.
sort of guidance.
It is a State Department official document. And insofar as we're talking about giving deference to the position that the executive branch has taken here, if the executive branch is speaking very differently in different contexts, it suggests that there is no deference due here. I think the deference that due is deference to the simple language of the statute. There's one more example. I see my time is up that I want to leave you with, which I see Judge Ginsburg is about to ask me a question. No. I'd ask the court to consider the Garavito case, which was a First Circuit case by now Justice, then Judge Breyer. And it was a reversal. He reversed the old INS when it denied a B1 visa to an individual who was coming in from Colombia to temporarily supervise a local gas station in Puerto Rico that he owned. He owned a corner gas station. And the INS kept him out. And Judge Breyer said, this is a perfect B1 visa. He's coming in, he's got to do some things to arrange the gas station, the corner gas station that he owned. There was no discussion or requirement of an international nexus. There was none. And this was a case where Judge Breyer reversed the INS. He wasn't accepting the findings there. He reversed the INS and found that the B1 should have been recorded. The last point I'll make before I go is I strongly disagree with the notion that the same word business in the statute can mean no international nexus for zone of interest purposes, but all of a sudden when you get to the merits, that same word in the same statute, because of something the BIA said, would have to be read, according to Mr. Yellen, to include a international nexus. It cannot be that the same word means two different things at two different times.
Mr. Weiss, I had been preparing to ask you a question, but didn't want to interrupt you.
Oh, okay.
And the question was, how about an exclusion case? And you just gave us.
Right. Yes. The Garavito case, yes. Thank you, Your Honor. And if I could just add, I'd like to end with a plea for the court to decide this case as quickly as the court could. I know that's an unusual plea to make, but I'm not kidding about the shortages that are out there. And this litigation, the sooner it is concluded, the sooner I hope we'll be in a position for our clients to go back and collecting the blood plasma that needs to be collected. Thank you.
Great.
Thank you very much.
Any further questions? Thank you, counsel. We'll take the case under advisement.